Morning, Council. This is the case of McQuarrie versus McQuarrie. And we appreciate your joining us virtually for this matter. We've come to expect technological glitches. If you should be the victim of one, don't worry, don't panic. We'll just take whatever time is necessary to get it fixed. It helps for bandwidth purposes if you mute when you're not speaking. If we have a question, we'll raise our hand. That's to signal among ourselves that we are in the queue. And it's a signal to you that when there's an appropriate stopping point, you should get to the question. You don't need to stop in the middle of a sentence. We don't intend that. But when is a good breaking point, please get to that question. Although we have allotted specific time to each of you, our practice is that as long as we have questions, we will keep asking them. We are here to educate ourselves with your assistance. So as long as we still need educating, we'll still keep asking questions. Don't worry about that either. That won't cut into any rebuttal time. You don't need to ask for permission. That's simply how we approach this process. So with that, Council, please enter your appearances.
Julie Nelson for Melvin McQuarrie.
Welcome, Ms. Nelson.
David Arrington for Jeanette Kendall.
Good to have you with us, Mr. Arrington. Welcome to you as well.
Thank you.
Let's begin.
May it please the court, Julie Nelson for appellant Melvin McQuarrie. Alimony is different than property distribution. There are not very many statutes that govern property distribution or tell us how to do it. It's filled in by case law and equity. But alimony has a lot of statutes that tell parties what to expect and trial courts what guidelines to follow. The statute at issue in this case is perhaps the most well-established of all the alimony presumptions, which is that alimony terminates upon remarriage. Now, the statute also tells us that there's a way to rebut the presumption. The parties can do it, or the trial court can do it, as long as the divorce decree specifically provides that the presumption is not in place. Now, the Court of Appeals, when it handled this case, it never considered the meaning of the words, unless the divorce decree specifically provides otherwise. It entirely skipped that step. But this court has made it clear that we need to first interpret a statute and then apply it to the case at hand, here, the divorce decree. When we look at the plain language of the words, unless the divorce decree specifically provides otherwise, we can see first that it's got to be in the divorce decree. It can't be in the findings. It can't be in another writing. And that's different than some states, but it's got to be in the divorce decree. And second, that divorce decree has to specifically provide otherwise. Now, the dictionary tells us that specifically means explicitly, precisely, definitely, exactly, particularly, and provide means to make a proviso or a stipulation, which in turn means an article or clause, and otherwise means in a different manner. This simply ratchets up what needs to be done to get around a normal provision. Justice Peterson, I saw your hand up.
Ms. Nelson, I'm just wondering, normally we would interpret a divorce decree like a contract. And so it seems plausible if you look at this, you could interpret this decree the way that the Court of Appeals did, that the parties intended for alimony to continue. If you're just reading it like a contract. So are you saying that, and that's what we would normally do with a decree, are you saying that this statutory provision kind of trumps general contract interpretation, that we're not just looking at whether the decree seems to intend specifically for alimony to continue in terms of just its intent? it has to say it in a particular way because of this statutory provision.
Yes. It has to. That statute, if we read those words out, then they don't mean anything. But the legislature tells us exactly what it wants us to do when it wants to rebut a presumption. And it doesn't have to be magic words, and it's not technical. This is not a difficult thing to do. But the legislature has said what we want it to do, and that makes perfect sense. It makes perfect sense from everything I can think of to buttress what that phrase means. It makes sense because the legislature first has the ability to require someone to do something specifically. They have the ability to require that something be done in a particular manner. We cited Stewart v. versus Bova. Yes, Justice Durant.
Yeah, I don't want to interrupt that, Ms. Nelson. You're done with that?
Well, the legislature has the ability to prescribe what people should do and how they should do it. And here it says that they should specifically provide otherwise. And we have several other cases where we interpret the statute first and then apply it to the decree. McDonald comes to mind. We have to interpret the word foreseeable and then apply it to the decree. So there's no reason that this would be different where there's a statute that governs it.
Ms. Nelson, would you have a stronger argument if the statute read explicitly?
I don't think so.
Specifically, is it, you don't see any difference in those meanings?
I don't think so. It could, I mean, it might be a little stronger, but the synonyms for specifically indicate explicitly as a synonym, and also precisely and exactly and particularly. So where explicitly is being used as a synonym and the antonyms are inference, then I think that specifically stands in that position. Justice Lee, I can't hear you.
Thank you. Can you hear me now? I think I was muted.
Yeah.
So I understand your position, and I definitely see some strength to it. I think this is an important case and an interesting one. Let me tell you what I'm kind of trying to think through, and then I want to give you a hypothetical. I take the point that specific might mean explicit, and I take the point that explicit might mean sort of no inferences, but I'm trying to understand or sort of think through how we would define what it means to make an inference and where the line between explicit statement and inference is. Because the way I understand language, we get meaning from like the semantic meaning of language, the meaning of words and syntax of sentences and stuff, but we also get meaning from, you know, sort of the pragmatic context of the word meaning and the syntactic and semantic meaning. And I'm just wondering if your position is we can only look at semantic meaning and not sort of pragmatic context.
Oh, not at all. To the contrary, but I think that the pragmatic context goes my way. And let me explain. The first is that the presumption that alimony terminates upon remarriage is about as entrenched as it gets. And it begs for something that is clear to overcome it. You've got this incredibly bright line presumption. And in order to overcome it, you just need a bright line sentence that says alimony extends beyond remarriage. This is not a difficult test. On the other hand, if you go the other way and you're allowing, like the policies here all go this way. If you have, you want absolute clarity, absolute notice to parties. Parties deserve to know what their divorce decrees say, and they deserve to be able to organize their lives around that. Well, if we have divorce decrees where you can cobble together different pieces, and then you can present an argument to the court and maybe argue that it's ambiguous, and now we're going to take parole evidence, and we're going to ask about the intention of the parties. Or, like I said, it doesn't even have to be the parties. The trial court can insert this clause. Well, now what do we do if the trial court refers to remarriage in a number of times? That just foments litigation as we go forward. None of those problems exist if we just have a sentence that says something to the effect of alimony terminates remarriage. And I think alimony extends beyond remarriage. And I think we can look to Lord versus Shaw for this exact problem that you've created. In Lord versus Shaw, the divorce decree said that alimony would extend for 36 months. And during that 36 months, the wife got remarried. And she argued that, well, alimony is supposed to extend for 36 months. And this court said, very briefly, because it really didn't need any more analysis, it said, no, it doesn't. Alimony also ends at remarriage. And you didn't overcome that. So I think the pragmatic considerations go this direction. And I think Lord versus Shaw is already helping us out with the inference. I think that if Lord versus Shaw had gone the other way, it would suggest that an inference might be enough here, but it doesn't.
And I think the question I'm asking is, what does it mean to make an inference, and what kinds of sources can we draw from in making inferences? Let me ask you my hypothetical, and I think it's related to Chief Justice Durant's question about explicit versus specific. Let's say that the legislature enacts a law that says all people born before January 1st, 2000 must be vaccinated for COVID-19. Does that specifically provide that people born after that date don't have to be vaccinated?
No, I don't think so.
Really?
Yeah, for the same reason that Lord versus Shaw comes out that way. I think that the model that you just created is Lord versus Shaw. Lord versus Shaw says alimony will go for 36 months.
You don't think people would understand a law that says all people born before such and such a date must be vaccinated? Means that what would be the point of putting the date in there? If that date isn't an operative part of the law, isn't the clear indication that people born before that date or born after that date rather, don't have to be vaccinated?
Well, maybe, but when you've got, I think that that's where, unless it specifically provides otherwise, does tell us what is required. We do have to look at the other side of what's going on here. And otherwise those words don't mean anything. If you can do it by inference, then we don't need those words there at all. Justice Rand.
If I could maybe take Justice Lee's hypothetical a step further. Let's assume we had a clause not that dissimilar from the one at hand, but stronger, that said, these and only these events will result in the termination of alimony. No other events shall result in the termination of alimony. It lists the events, and remarriage is not one of them. Does that even require an inference at all?
No, I don't think so. And other states have made that interpretation. Other states.
So that's satisfactory. That would do the trick in your eyes.
At least according to other states, yes.
Well, how about according to you? Is that not?
I think it would.
It might highlight a potential difference between explicit and specific. I mean, it's certainly specific in the sense that it clearly imports the meaning that remarriage does not terminate alimony.
That's right. And I think that,
go ahead.
Well, I think that in your hypothetical, it's important to recognize that that is in the part that's discussing alimony, and it's directly making comments about alimony. None of the provisions in this decree that refer to remarriage or anything else actually are in the alimony section. And all of the other provisions are property distribution provisions, which are different than alimony, like I said at the beginning, because there aren't statutes that tell us when you can stop buying your ex-wife a car.
So you would probably characterize that as an example of, we don't need the magic words, but that clearly conveys the meaning.
Right. I can think of a number of ways to do it. And certainly we can come up with some inartfully drafted provisions that would be a close call, but we're trying to eliminate the vast majority of them.
I take your pragmatic point. I think it's a strong one.
Justice Jimenez?
No, I want to offer you a definition, because I take your point being that if the provision said nothing else, no other act shall terminate alimony is sufficiently clear. And I want to ask you if it fits within this definition of the operative language in the statute specifically provides otherwise. What if we were to define it as meaning a clear and definite statement to the contrary, and that neither requires nor relies upon an inference?
I think that makes sense. Could you say it again?
A clear and definite statement to the contrary, and that neither requires nor relies upon an inference.
Yeah, I think that makes sense. And I also think it's consistent with this court's decision in Hertzky versus Snyder, which is just a 2017 case that also is addressing, it's not alimony at all, but it's talking about when somebody gets divorced, whether they automatically are terminated from the life insurance policy.
And to be clear, we don't need a talismanic phrase then, right? A statement like Justice Durant's, or one that specifically refers to the statute, or one that doesn't refer to the statute, but specifically refers to remarriage. A second question, I mean, there are a lot of cases out there, it seems to me, around the country, as I've kind of just quickly looked at this. Which cases go the other way?
Well, that's a great question. The only one that has come up is In re Han, which is a Colorado Court of Appeals case, but it's very distinguishable because it had the provision that Justice Durant was talking about that said alimony may only be terminated for these reasons, may only be modified. It said it may only be modified, or it's non-modifiable or something. And the Colorado Court of Appeals decided that modifiable and terminable were close enough that they would encompass that. Well, Arizona, in looking at In re Han, said, no, in Arizona, that's not good enough. And I think that in Utah, we also would say that's not good enough because we have Utah cases that suggest that you cannot put into a divorce decree that this is non-modifiable because a trial court always retains the ability to modify a divorce decree. So In re Han is the only one that really goes the other way that has surfaced, and the other side has provided no examples of the havoc that supposedly is going to be wreaked in these states that require express language.
It seems to me that what the legislature has done here is recognize that remarriage is a very frequent material change of circumstance that would require a determination, if we didn't say something specific about it, of whether or not the parties saw that as a material change of circumstance. And what we've said for ages is it is, and it automatically terminates alimony unless we want to know that the parties clearly understood this presumption, and disclaimed this presumption, because we don't want to be litigating this like we are today.
Right. And that's why it's automatic. It's a legally cognizable event. It's not like cohabitation where you have to like hire a private investigator to follow your wife around. She got remarried. Alimony ends unless it's very, very clear to everybody that it was supposed to extend. What I don't think we want is people to be going back through their old divorce decrees now thinking, ooh, I wonder if maybe alimony could extend beyond remarriage.
And this seems to me to be a little bit of a gotcha. Your client argued for a change in circumstance, and then you were on the other side of this. I'm guessing that at the time that this was brought, nobody was envisioning that this was going to be brought as kind of a cross petition, right? It's all right. I mean, this wasn't brought independently.
Well, that's true, and it was labeled as a petition to modify, but the content of it was that she had remarried, and under this provision, it would automatically terminate.
But I'm saying it was in response to something that your client had done, to your client's petition.
No, the other side had filed a petition, an order to show cause or something, and our side then brought this.
I'm sorry, I had it backwards. I'm sorry, Ms. Nelson.
Yes. Does that answer your question?
Yep. Tells me I got it wrong.
I think we also need to think about what the legislature is trying to say in all the other statutes when it talks about unless specifically provided otherwise. Our footnote 3 lists about 20 statutes that use specifically provided. When you kind of break them down, eliminating the ones that aren't an unless clause, several of them refer to unless specifically provided otherwise by another statute. Well, surely the statute isn't supposed to be inferring anything or by omission. Surely the statute is explicitly stating what it means. And in the others that refer to a contract, they're the sorts of areas of the law where we expect parties to use precise language. One is about a trust document, an insurance document, an LLC document. Those are the sorts of areas where we expect precision and we expect clarity. And it not only is it not asking much here, it's the exact same sort of factual scenario where you expect precision in order to overcome this presumption.
If we were to reject the idea that specifically provides means no inferences and instead read it as clear, because sometimes specific means clear or unambiguous. Do we have to affirm the Court of Appeals? Because most of your brief rests on that point. And I'm wondering, for example, what we do with footnote 4 of the decree and at least the arguable inference to draw from paragraph 10 in combination with footnote 4, the multiple, the plural spouses point, which sounds like you were making an argument in the Court of Appeals or predecessor counsel was that you're not really making about footnote 4 here.
Well, as I said at the very beginning, all of the alimony is different than property settlement. And so we'll talk about footnote 4, but I want to put it in context here that all the other references to future spouses and remarriage are in property distribution. And that makes sense because some of these, this is a very unusual decree, right? And it has very bizarre provisions in it about things that will extend beyond the divorce. And then it specifies that some of them will terminate if she remarries and some of them won't. So like paragraph 7 says she's going to be employed by his company forever. He may never terminate her. And he's going to provide her with health insurance.
Can I ask you about footnote 4 in particular, though? Because, I mean, that's the one that seems to me to be talking about alimony.
Sure, but it's in the annuity paragraph, right? And the annuity, in the annuity paragraph, if we look at the text of the annuity paragraph, tells us that the annuity is intended to provide income to her for her lifetime, which clearly could be beyond alimony because alimony will end at some point. And the annuity is intended to provide a stream of income for her lifetime. And then when we look at footnote 4, it does refer to alimony, but it also refers to the annuity. It says that she's going to pay the tax liability on the annuity, but he's going to pay the tax liability on the alimony for so long as the alimony is paid, obviously contemplating that alimony will at some point end. But it doesn't say that these triannual meetings are going to end, nor does it say that she can't modify her annuity during that period, nor does it say that the sharing any of the documentation or including new property holding assets will end. All of those things continue beyond, even if alimony isn't paid, whether that's because
help me with whether I'm misunderstanding this, Ms. Nelson. The triannual meetings at which spouses, plural, may not attend are specifically talking about the possibility of making adjustments to alimony based on standard of living. Is that correct?
It talks about standard of living, and it says that it may include adjustments to alimony, but it could include all kinds of other things. Like, for example, they've got these new property holding and assets that they have to reconcile. It's a variable annuity, meaning that she can change the terms of the annuity. So I think that, yeah, if alimony is being paid, we can discuss that. But if alimony is not being paid, we still are going to have these meetings because we're still going to talk about whether you want to vary the annuity. And we're going to talk about whether we want to redivide the property distribution. And these meetings are going to go on forever, regardless of whether alimony is paid.
Thank you.
And all the other references are clearly property settlement references. And you have to say whether they're specifically going to go beyond remarriage because there is no presumption. Well, alimony isn't like that. There is a presumption. It's the one scenario where you don't need to say. But what the other side seems to prefer is that you expressly state that alimony ends upon remarriage. Well, that just flips the presumption on its head. That invites, that's the exact opposite. That's cutting out the operative language. And the Court of Appeals seemed to think that strengthening an inference of an omission was adequate. It relied on the omission of the language in paragraph 9 and 10, but that's clearly the opposite of what the statute says. I see my time is up. I'll reserve for rebuttal.
Thank you, Ms. Nelson. Mr. Arrington.
Thank you, Justice Durant. Justices, may it please the court, Dave Arrington for Jeanette Kendall. As the court's faced with the task of determining what the legislature intended, and in part to determine the ordinary and accepted meaning of specifically. We've seen a battle of dictionaries. It's the dictionary that underlies Melvin's approach to this. In this case, highlights.
Mr. Arrington, I have to say, I might not see it so much as a battle. I realize, I might be alone. But it seems to me that you're trying to word you read the word specifically right out of the statute. Specifically has to mean something. And I am wondering what's the matter with the definition that I provided earlier. So a clear and definite statement to the contrary that neither requires nor relies upon an inference.
The dictionary would support half of that definition.
I think the dictionary would support all of it. I mean,
It could. It depends. There are varieties of definitions. Clear, unambiguous, leaving no doubt as to meaning, those are things we see in it. And if we're going to decide, they don't necessarily mean that that's not going to be something you can infer or read from the four corners of a document. We happen to have also an uncommon bit of empirical evidence from the surreplies corpus analysis, which helps us understand what the parties governed by this statute understand this term to mean. You know, one of the points that opposing counsel suggested is the parties deserve to know what their decree says. And I don't know any better place to find that than the decree that they crafted. As here, without attorneys, they put together these terms, the decree became the term. They understood that they were going to have, they understood what the commissioner understood, what the district court understood, what a united panel of the Court of Appeals understood.
Maybe that's how you would read the decree, and that's the better reading of the decree. But you have different relief there, don't you? I mean, if the argument is this is what all the parties intended, isn't reformation a possibility?
I don't know. I don't know if that could be, or if you're talking about something like a material change that would have to.
I just think if you're saying this is clear and unambiguous, and the evidence from the stipulation and everything else is that everybody understood and intended that this is just a Scrivener's error, that this was left out, and to reflect the clear intent of the parties, I think we have legal doctrines out there that would allow you to get there. But I think the legislature was clearly telling us and telling the parties, if you want to get rid of this presumption, here's the trick. Refer to the statute. Refer to remarriage, right? Or make a statement as strong and broad as the one that the chief articulated. But anything that requires an inference, right? Anything that's not clear and unambiguous from the document itself, that's out of bounds.
We have also an added advantage when we're trying to understand the legislative intent here, when we're talking about these different definitions. We have the uncommon discussion of the sponsor of this amendment.
Really, I'm going to tell you that the legislative history here is virtually of no moment to me, to be candid about it. I think that we don't get there unless we find the statute to be ambiguous. And I am hard pressed to understand why this is not a plain and unambiguous statute on its face.
Well, when you consider some very powerful corpus analysis, it suggests that the word specifically is understood almost all the time to mean something other than specific, to mean precise, exact, one of three iterations of a phrase, that limited. Instead, it means that it's an emphatic term, that it's acquired a function rather than a distinct meaning to modify the verb in front of it. You have what the parties who are governed by the statute know this term means. You have an understanding of what was understood at the time this was enacted. That means, yes.
Can I ask you about that? So in terms of what parties would understand, and I'm talking parties generally, not necessarily the two parties to this litigation, but help me understand how somebody could read the language specifically provide and not believe that that meant they needed a specific provision if they wanted to overcome the presumption.
Even that statement, I think, assumes a definition. Whether we have a judicial intuition, a personal intuition, our understanding from our own training, what does the word mean? You know, when you see how it was used, and I don't think we can discount, and I would take issue there, I don't think we can discount what the legislature discussed on the floor in describing the purposes for this to help us understand what that means, because it is ambiguous.
I'm sorry. May I interrupt for one moment, Mr. Arrington? Just as an addendum to Justice Pierce's question, which I think is an excellent one. As I understand your position at bottom, it is specific means intent parties is clear from the terms of the contract. Correct?
Correct. It would mean that you have a divorce decree. A divorce decree specifically provides for post-remarriage alimony when the party's intent is free from ambiguity, clear, leaving no question as to meaning. And you can draw that intent either from saying it in two or three iterations of a mandatory phrase, or you can read the decree as decrees are supposed to be construed.
You know, and this goes back, and I'm sorry for hijacking Justice Pierce's question, but specific seems to me to suggest a higher level of higher standard, let's say, and the party's intent is clear. I mean, you know, that's kind of garden variety contract interpretation. We're looking at the party's intent and where it's clear, we don't go beyond the contract and look at parole evidence. Or in the case of a statute, we don't, as Justice Himonas pointed out, we don't look to legislative history. So yeah, that's the garden variety clear. Specific seems to be suggesting a higher level of particularity than you get to simply looking at all the contract to assess the clear intent. And I get back to Justice Pierce's question: how do the draft look at specific and come to the conclusion that clearly manifests intent?
If the legislature used, why we would presume that the legislature would choose words advisedly. If we have an understanding of what specifically means, how it's used, how people talk, how Representative Livingston was thinking, or Representative Atwood was thinking, when they put this term in there, you start to see more the importance of the delexicalized meaning and understanding of that term. They're not construing contracts in their day-to-day lives as they sit down to divide their estates and give up interests in business in exchange for 31 years of payments based on the definitions that might be discussed in court. Go ahead, Your Honor, sorry.
It seems like in common parlance, for instance, I might ask my attorney, is this contract clear? Is that the same question as asking, is this contract specific?
If we define specific based on our understanding, for example, of what the corpus analysis shows us, yes. Also, if you have the definition group from even any of these dictionaries that say it also means clear, unambiguous, no question about what was intended, no question in a type of decree not present in any of the cases cited to the court. None of them had a decree even resembling this, where future spouses were even referenced, much less in the context of alimony. Yes, Justice. Oh, Justice Peterson, sorry.
I think that on top of the words specifically, though, it is in the context of the statute saying the general rule is termination at remarriage. And so it has to be specific enough that it overcomes the general presumption. And that seems to add an additional, to sort of heighten how specific it has to be. it's almost rebutting a presumption of termination. It needs to be specific enough that it's clear the statute does not apply. Could you speak to that?
It is rebutting a presumption, and it is specific enough if the decree is clear and unambiguous, leaving no question as to intent. That is sufficient enough. The legislators, for whatever purpose we want to make with legislative history, said that their point was to enforce the parties' agreement, that whereby they agree to have alimony continue after remarriage, and that contract, quote unquote, that contract, and that kind of contract, quote unquote, was the one they wanted to enforce, not a different kind of contract thought up by the legislature that included a more stringent term. What the parties thought, what the parties said, what the term was that the parties agreed to enforce, they wanted to enforce the parties' intent. And that can be sufficiently stated if it's clear, unambiguous, and any agreement provides for what the terms say, whether it's by reciting exactly a statute or by reading it from the four corners of the agreement. Where here, as Justice Lee was observing, you have an agreement where the parties are to meet every 3 years, and they're going to discuss standard of living. Jeanette is supposed to have the same standard of living, and if that means raising alimony, that's what she gets.
Could I jump in here, Mr. Erickson, and ask something? As I indicated to Ms. Nelson, I find both sides' arguments to have some force to them, and I find this to be a difficult question. But let me push back on your position or indicate what I think might be a strong argument the other way. It's somewhat building on what my colleagues have suggested, but I'm wondering if the term specific under our statute has some sort of specialized meaning that means specific in the terms of specify, making reference to. And I wonder if the Lord case and the Hertzke case essentially are both, I recognize Hertzke is under a different subsection of the statute, but if they're roughly getting at this principle that if you want to opt out of the statutory presumption, you have to, not in magic words necessarily, but you have to make specific reference to the statutory presumption in some way and indicate that you're overriding it. What's wrong with that way of thinking?
I think we can see that the sponsor, the legislators, didn't have that intent. And I don't think we can disregard the evidence that we have of what that term is understood to mean at the time this was enacted, the years surrounding 1979. That term is not generally understood to mean that type of precision. It's understood to be an emphatic term. It's entirely consistent to read it that way in this provision, particularly when the points identified and the purposes identified were to enforce the parties' agreement, the parties' commitment, the parties' intent. And when you can define that.
When statutory words have ambiguity in them, they are, the ambiguity is resolved over time through judicial decisions. And I'm just wondering if Lord and Hertzke haven't sort of resolved or at least pointed in the direction of, well, it doesn't necessarily mean either clear or even explicit in some sort of broad general sense. What it means is you have to make specific reference to the presumption and indicate that you're overriding it in some way.
Well, we know in Hertzke that there was a statutory provision where the court had to make exact findings. The court found that you actually have to include the statutory language to comply there. And we also have to realize that different legislators can have something different in mind when they use a term. Here, it's incompatible to suggest that the sponsor, Representative Livingston and Representative Atwood, wanted to have that type of precision when they were saying enforce the parties in contract, the parties' intent, and then imagine so that they would have an exception when that was contracted for. And then at the same breath, imagine that the legislature wanted to erect a technical language barrier that would prevent the enforcement of a number of these these decrees, like this one, where you have a decree, as the Court of Appeals observed, the only reasonable interpretation is that the parties anticipated and wanted to have alimony continue to supplement, that the annuity would supplement for Jeanette's life the alimony she was going to get, that the parties would meet every 3 years and discuss increasing her alimony. It's when you have that type of decree and you understand what specifically is understood to mean by those the statutes intended to govern, there may be some dissonance between how a different statute is construed versus another statute.
If we were trying to make a decision purely on the basis of getting a clear rule out there for parties to divorce decrees, wouldn't the notion of specificity that I suggested, which might line up with what Justice Sabonis was suggesting earlier, I'm not sure, but I think it might, wouldn't that be clearer? And then once we hand down a decision that cements it and maybe says, in line with Lord and possibly Hertzky, this is the rule. Isn't that easier to contract around than a standard that says you can make inferences of whatever sort, but as long as the inference, points in the direction of overriding the presumption, then the presumption is overridden. Isn't that going to promote more litigation and uncertainty?
I think that one way or the other, there can be litigation, whether the chosen phrase meets the standard the court defines versus having to look at a contract like ours. But we have an issue where we know what the legislature wanted to protect. The court isn't just called upon to craft an intent that minimizes litigation. It's to identify what the legislature intended. And if they intended to enforce the parties' agreement, and if specifically really is understood to mean more of an emphatic use, not raising it beyond its other definition of being clear, unambiguous, no question as to meaning, that contract can provide either way that is the party's intent. And courts construe them all the time. Justice Simonis.
Thank you. So I want to make sure that I have this right. You are not suggesting that the phrase does no work. In other words, that we have this presumption out there. You're essentially saying that what the phrase adds is that if there's an ambiguity in the contract, you haven't or the decree of divorce, you haven't overcome it. But if from the four corners of the document you can discern, the clear and unambiguous intent of the parties, right? Or read together, the contract is the decree of divorce is clear and ambiguous. You've overcome the presumption. That's effectively what you're saying.
That's true.
Okay, so here, part of the problem I'm having with that is you are suggesting that the legislatures, clear and unambiguous or plain and unambiguous are terms of art that we use thousands of times, right? And you're suggesting that rather than use that term of art that we assume the legislature is familiar with, they chose to shorthand that into a different phrase, into specifically provides, which is foreign, frankly. I mean, that's not the language that we ever use in talking about, is something ambiguous or non-ambiguous. And that is, I'm really struggling with that leap, because it seems to me, to the Chief's point, it really is adding another layer beyond just clear and unambiguous, right? And maybe to Justice Lee's point, it's talking about the method of which you have to demonstrate that. Would you address that?
One thing that the prior cases never had when analyzing what this term specifically might mean is a valuable piece of empirical evidence about what parties understand specifically to mean. These are the people who are governed by the statute, not the ones just overseeing litigation. These are the people who are drafting these, who are entering into these contracts, often without lawyers, how they understand specifically to mean and how it functions. That it means that the decree really provides this, clearly provides this, unambiguously provides this. This is powerful evidence, and I don't think we can sweep it under the rug. It was never present in any of these other cases. The courts never had the benefit of that
I'm
perspective.
not suggesting it gets swept under the rug. I tend to agree with you that the corpus tool is a very powerful tool in the court's toolbox. But there are others, including the notion that the legislature is aware of, our case law and the long history of how we indicate, something is non-ambiguous. And in your view has chosen a phrase which is very foreign or alien to how we would typically do that. But you want it to mean the exact same thing, and that's what I'm struggling with. What do we do with this notion?
I think courts have had a lot of experience in construing decrees or agreements to determine if it provides something in a clear way, in an unambiguous way that doesn't leave question as to meaning. And I don't think that that is the challenge. I can sense that there's a concern about how do we reconcile, or do we reconcile with all these other statutes, or are there different constructions to deal with those statutes, other meanings that might apply there? Like Herzog, we have a court finding requirement has actually requires you to include the statutory language according to Justice Durham there. But we have evidence here of what the legislature actually meant. And we have evidence that specifically has a meaning that's a little different than some suppose. It's become a function more than an independent semantic contributor to the word it modifies. If we acknowledge that, I think we help advance statutory construction. If we're trying to offer definitions that are understood by the parties, the individuals, husbands and wives from all walks of life who are governed by this statute, who are oftentimes preparing these with an office depot form or otherwise without attorneys, as Jeanette and Melvin did here. These are the people who we need to focus on for the understanding of this provision. We have evidence suggesting what that is.
Doesn't that whole argument go against looking at the corpus and what it meant in 1979? I mean, if you're talking about giving this language meaning to those who are being governed by it, right? Do we really want to create laws or create interpretations that say you need to go back and look at the corpus in 79, you pro se folks, to understand what you're required to do here? I mean, doesn't your argument speak in favor of just giving it the plain meaning? Specifically provide means you have to have a specific provision that speaks to this issue.
The corpus helps us understand what they're thinking around the years of 1979. We see how it's used. The parties themselves don't have to go there, but we have to realize how they understand it.
Well, I guess we may just disagree on that, on what sort of favors we're doing for unrepresented parties. If they're required to read our case law or go back into a corpus search to understand what that language requires them to do.
I think that when we say we have to state what it specifically provides, we're again back at this definition. And a decree can specifically provide, and does specifically provide, for post-remarriage alimony if it does so clearly, unambiguously, with no question of intent, and the agreement provides for that. It specifically isn't required to use one or two iterations of an exact phrase. Then you look at the decree as a whole, as court often does, to discern that intent, which leapt out at the commissioner, a united panel of the Court of Appeals, the district judge. Melvin himself did not dispute that alimony, when he was arguing in the Court of Appeals, that alimony was to continue after remarriage. We're all sitting here reading this agreement. We know what the parties intended. That's the irony. We know what they understood. The legislature wanted to enforce that agreement. It was the parties' agreement, not one that the legislature thought up to include a higher standard of expression. They wanted the parties' agreement. They said so. They didn't want to use a term that they thought would, in the same breath, turn the exception against itself and prohibit enforcement in a significant number of cases, maybe even most of them.
When you say, Mr. Arrington, this goes back to a point made by Justice Simonis. You say the legislature wanted the courts to do what they do. Typically, yeah, what we do is we look at a contract, we determine whether there are ambiguities. In the event there are not, we conclude there's a clear meaning, and we enforce the contract consistent with that meaning. And I just wonder, I guess, if that's a very good way for the legislature to suggest we ought to go about our normal interpretive process by including the word specific in there. It seems to me to suggest that an alteration of the traditional contract interpretation.
I can barely think of a statute where I wouldn't stop and think that the legislature might have done something a little better in a different way. Here, when we understand what specifically is understood to mean, then we're looking at a phrase that says in the statute, unless a decree of divorce clearly or actually unambiguously provides otherwise, then the question is, did this decree provide in that fashion for post-remarriage alimony? And the answer to that, we read the decree as decrees are always construed.
Okay, fair enough. Thank you for your argument, Mr. Arrington.
Thank
Are
you.
there other questions of Mr. Arrington? Okay, we'll move back then to Ms. Nelson.
Does the court have any questions for me?
I do. So, Mr. Halpern, analysis, the corpus analysis, right, is you've not had an opportunity to respond to, and it's it's a really good analysis. I wonder what you have to say in response. And the two, I want to ask you about this concept of reforming. I mean, am I correct in understanding that there exists under the concept of reformation, that either through a 60B or a petition to modify, that parties to a decree of divorce could seek to reform a decree to make it explicit if the court, on taking evidence, determined that in fact the decree did not correctly reflect the intention and understanding of the parties?
Of course. Yes, you're right on that point. And it does point out that a petition to modify is always available and could be used for any other things, including to say that alimony has to terminate for, because Melvin can't pay it or Jeanette can meet her own needs. But yes, of course, that's still available.
No, I'm sorry. Please go ahead.
To the corpus analysis, but if you wanted
Yes, please.
All right. The corpus analysis does two things. One is it focuses only on specific. It doesn't even talk about provide. It assumes that provide isn't doing any lifting. And it says that specific is like an emphasis. And so maybe we say it really provides.
Yeah, but Mr. Halpern takes issue with your co-location analysis that ties it to provide, correct?
Yes, true. But his conclusion is that specific is just an emphasis on the word provide. We can't read it out, as has already been discussed. We can't read it out. We have to assume that the legislature used each word advisedly. So if they're just emphasizing that they want it to provide, then they mean they truly want it to provide. And the word provide itself can't be done by omission. In fact, they're arguably opposites of each other. The legislature is really clear about what it wanted. It wanted people to be able to get around the presumption. And it was also really clear about how to do it. You have to specifically provide it. Now, if we want to say you have to really provide it, or you have to actually provide it, or you have to explicitly provide it, you still have to provide it. And this decree hasn't done that.
I think this is a fair point. I also, I think this is somewhat building on something Justice Pierce said earlier, but I just wonder if a general corpus analysis is looking at the right language community here, if this hasn't sort of become a term of art in this field that means specify, directly by specific reference.
Well, I pointed to numerous other cases that are not family law cases that are nationwide that talk about specifically provide in contrast to anything that can be done by inference. So if a corpus is a
I was
body,
actually trying to agree with you, just to be clear.
yeah, well,
Yeah.
but I think that that's where we see it. This is, we know what it means. We know what it means in these other cases. We know what it means when we're talking about it. I disagree, obviously, with Mr. Harrington that when the parties mean specifically provide, they mean we'll just refer to remarriage in several places and hope that that does it. I don't think that's what specific means at all. There are no further questions. I will waive the rest of my rebuttal time.
Thank you, Ms.
Thank you.
Nelson, and thank you, Mr. Harrington. We appreciate your briefing and your argument. It's been helpful to us. We'll take this matter under advisement. We'll take a brief recess at this time until 11:30, at which time we will return and hear the case of McQuarrie versus Gibson. Court is in recess.